All right, here is the replay from April 6th. Right now, so hello and welcome to tonight's Zoom meeting that is for basically study prep for the July bar exam, whether you are in California or somewhere else. I just want to say that the best thing that you can do is to set up a study schedule. Really, I strongly consider that everyone should do a bar review program, whether it's one of the big boys or somebody else is totally up to you. I used Bar Exam Doctor, and as you see here tonight, Todd, the president and owner of Bar Exam Doctor, is here, and he is going to talk to you after I show you my screen on how to set up a practice essay for civil procedure. So let me get started here. Sharing screen. Okay. Okay, so I've now shared my screen. I'm hoping that you can see it. I can't, so you guys have to, somebody nod your head. Can you see it? Okay. So as you can see, what I did was I took this civil procedure hypothetical and I put it on the left side of my screen, and I put my Word document on the right side of my screen. Then I went down into my search bar down at the bottom for Windows, and I typed in timer, and I found this really nifty, cool alarm clock timer that I use for when I want to time myself. Now, what I want to say about timing is you can look at this civil procedure hypothetical, and it's got 3 paragraphs. Okay, it's not going to take a lot of time to read it. And a lot of people, when I took the bar exam at the Oakland Convention Center, instead of sitting down and spending the time to read the whole thing through one time, they immediately started either writing notes or typing. I'm going to suggest to you right now, read. And that means read that thing all the way through to where it says discuss at the bottom. And it's to your benefit, because that will give you your first comprehension of what you need to do. And then the second time you read it, you're going to pick up stuff you missed the first time because you were anxious and you were racing to read it. So you sit down and you read the hypothetical, you read what the bar examiner's questions that you are to answer, and then on your screen that, on your Word document that you're going to put your answer, you can put your notes right in there. And I'm going to tell you again, the last meeting that we had, the guest I had at that time had made a comment that, you know, you get note paper from the bar examiners, you got to show both sides of it, use your note paper. Don't use the note paper. Everything that you write down on that note paper, you got to transfer to your answer. So why not use your actual essay answer as your notepad, not something that you got to cut and paste into or move things around, because you can cut and paste after all your notes are in there into the different sections that you need to. So for this hypothetical, I've set the timer for 50 minutes. If you were to read this hypothetical through once, it probably would take you 2 minutes, if that. Okay, so you read the hypothetical, then you're going to read it again, because now you know it's a civil procedure question, and you've got 3 questions you have to answer. One's on summary judgment, one's on compelling production in discovery, and the other one is contempt for refusing the discovery request. pretty much 3 simple answers. And now you need to go in and you need to read it and decide who is the P, who is the D, who's doing the violation, who's filing the motions. You need to know all that stuff, and you can put it right into your essay answer. And I really want you to do that. So if this one, it says Pam P is the patient injured in a nursing home fire. She brought suit for $200,000 against the home operators D in federal district court in state X, where the nursing home in which P resides is located. Jurisdiction was properly based on diversity of citizenship. That right there should tell you 2 things. You don't have to talk about subject matter jurisdiction. It's already there. There's a diversity suit. She's got 200,000. D is a resident of the state. It's in federal court. So under the law of the state X, it says failure of the nursing home to install smoke detectors in each patient's room is considered negligence per se. That brings up an Erie issue. The Erie doctrine is basically about forum shopping. And if you're in federal court, the rule is that the federal will apply the substantive law of the state. Negligence per se is substantive law. So right there, you've got a whole bunch of information that you know that you're going to need for that summary judgment or the compel production or the contempt. You don't know what it is yet until you read further. So it says P alleged failure to install the device. D denied all allegations. So we've got a complaint, we've got an answer. P promptly moved for summary judgment as to liability, attached her own sworn affidavit stating no smoke detector had been installed in her room. Well, first of all, the answer denied that there was any smoke detectors. But when someone applies for summary judgment, the other side has to answer. D's attorney responded with saying, my client stands by its answer in this case. That's not good enough. Okay, the rule is that if somebody files for SJ and produces information, the other side has to produce information to counter it. This guy did not. D did not. So the first question was the district court. Well, let me finish here. The court denied the motion, the summary judgment. Okay, well, the court can rule wrong. Okay, so P's motion for summary judgment as liability, did the court rule correctly? No, because D did not answer. So that's the first question right there in a nutshell. Now you got to put it on paper. You got to do IRAC. You've got to do your issue. Motion for summary judgment denied. You have to put in your rule for summary judgment. You have to put your rule for P and D, what they have to do to prove it. Then you have to conclude that the motion was basically denied and it shouldn't have been. Okay, so go on to the next. And the final, it says P initiated discovery. Okay, so we're on the next set. It says P requested D to produce an inspection of its fire investigation report. Okay, so hoping the fire investigation, early investigation since demolished homes showed no smoke detectors present. D refused to comply with the discovery request. All right, P moved to compel. So we don't even have to go any further for answer 2. We know it says P's motion to compel production of the fire investigators report. Is that allowed? Well, in federal court, you can make a request for discovery on anything that's relevant to the matter. Would the fire investigation report be relevant? Of course it would. But the problem is one thing, anticipation of litigation. Anything that is brought by an attorney, an investigation, work notes, all that is basically sometimes privileged. But here in this instance, it says the early investigation. So did they know that there was going to be a lawsuit? Well, maybe, but the lawsuit wasn't filed yet. then she can compel this investigation because it's not in anticipation. So, did the court rule correctly? So P moved to compel production, and D did not give it. So then it says that after D did not produce the report, P went to the court, and that's what you have to do. When you ask for discovery and somebody doesn't give it to you, you have to go to the court and get an order for a motion to compel. And that's in both California and federal that you have to do that. Now, if they go to court and the court orders the report to be produced, at that particular time, both federally and in California, the court can order D to produce it, plus it can cite him in contempt of court and order sanctions. That is a wiggle room that the court can or cannot. In other words, they get to pick. And here they picked that they were going to hold him in contempt. So that pretty much completes this essay. And how much time did I spend on talking about this? A whole heck of a lot of time, right? But the whole thing is that I could actually go down the page and IRAC and put all my stuff in that I need to on each one. And you should always put, if you've got question 1, you should put that up there first. Then what is your issue? Well, your issue is the summary judgment denial proper. And then you can say, well, the rule is for summary judgment is that if one side produces information and the other side doesn't, then automatically summary judgment is supposed to just go to the side that produced the information. So, and you can actually then go, therefore, or I should say here in the analysis, P produced an affidavit, no smoke detector in her room, and D didn't produce anything, just said, look, I'm denying it, and therefore conclude that they won. So that's how simple some of these rules are. Now, this is a very simple civil procedure. Sometimes you get them really simple and you can spend a lot of time arguing back and forth. And that's probably what I would do with this one, because I don't think that I could use a whole hour on something this simple. So with that said, if you set up your screen the way that I did with the civil procedure hypo, with your essay answer in a Word doc and your timer, when that 50 minutes goes off, then you can check everything. You can read through your answer, make sure that you didn't have incomplete sentences, make sure that you didn't do conclusory statements in your analysis, because the conclusion is supposed to go in the conclusion. A lot of people, when they do that, they assume that, oh, because it's not, I concluded above in the analysis that that's good enough. That's not what they want. They want to see your analysis. And then after I read through it, I might read through the whole fact pattern again one more time, just to make sure that I used every fact that was in there that needed to be in my essay. So with that said, I am going to turn this over to Todd, and he's going to give you tips as well. So I hope that helps you.
Can you hear me okay?
Yep.
All right. Hi, my name is Todd. I'm the owner of a bar exam doctor. We've been around for about 10 years now, over 10 years now. We're a website that's purely online to help students pass the bar exam. We probably were way ahead of our time before the bar exam became basically virtual. And we had a website, I created a website about over 10 years ago where I wanted the ability to take a PT or an essay completely online. I didn't want to print. I didn't want to do that crap. I want to just do it online. I want to have my screen where I had my PT on one side of the screen and I want to type my answer on the right side. And for the first time in the past with Jennifer speaking, I actually wrote notes down so I can remember things I'm going to discuss and do it in a way that's clear and concise. So I'm going to go into a few things of some thoughts that when she was discussing, but everything she said was dead on. I mean, Jennifer has probably perfected things that she's learned over the time to basically eventually pass the bar exam. I mean, that's the bar exam, right? It's a marathon, right? It's not going to happen overnight, and that's okay. I mean, I did a TikTok video not too long ago where I said, what's the difference between someone who took the bar exam 6 times or 12 times or 48 times? Nothing, right? You can't go look at the bar exam website, look up the Cal Bar on somebody. It just says, I think it'll say like when they went to law school. I don't know if it's going to say much more than that, but there are people who basically took it a bunch of times and have passed, and they are very successful. So if it took a bunch of times, so be it. And so moving forward, so when you do exams on our website, you see the essay or the PT on one side and you do the question on the other side. Starting about a few weeks ago, I now have these videos where I actually have one of our graders who grades exams. He's licensed in several states. I think Jennifer even used him. He's one of our tutors and our graders. He's very smart, very skilled, has an educational background, and we go talk back and forth about things that he's learned over the years working for us and on his own that will help people improve their writing. So we put these videos, they're about 15, 20-minute videos. We're doing them weekly. We're trying to do them every week. Starting a few weeks ago, we're going to just keep loading them in. I loaded them into our website, so they're free. You can just scroll to barexamdoctor.com. Again, barexamdoctor.com, and you scroll down from the top just a little bit and you'll see the videos, and they're all through YouTube. So you can click to the next, and go from there. So moving forward, talking about some of the things that Jennifer had gone over, it's funny, it brings me up to a very specific relevant thing recently. So one of the things I do on the side is I help a dentist expert, right? Here's a doctor, he's been a doctor for 40 years, right? And he's doing a report and he's doing it for a lawyer, and he shows it to me and he says, what do you think? And I said, what is this? This is not like, it's not written in a way that a lawyer's going to understand, that the lawyer wants to speak that way. And he's just like, what do you mean? And I explained to him that like in law, it's like a math formula, right? And literally here I'm teaching a doctor over 40 years, very experienced doctor's been in lots of cases, showing him how to write towards the way for a lawyer to basically best use his report, right? Just to spill it down in more of an English type way. Yes, there's going to be stuff that I will never understand, no one else can understand, but he will because he's the doctor. But the actual format, the fact of basically, as Jennifer's pointing out, that don't rush through it. Like he had said, I just started writing. It's like exactly from our students. I just started writing. Don't just start writing, right? Slow down. You should dedicate it probably a good solid 10 minutes before you actually write an essay. You should tear that apart, that essay question. And I don't mean rip it in paper, but I mean analyze it, right? And outline it. Outline it. What does someone really mean outlining it? Well, what it really means and what we tell our students and we try to stress is like, write an outline of how you're going to write your answer. And you can, the answer, the question lays it out for you, right? You take your questions at the bottom, what they're asking. There's your two headlines, right? There's your two topics of what you're going to start with. Okay, now what? Okay, now you're going to say, what are the issues, right? The issues are probably going to come across from the fact pattern. So write down your issues below the actual question, right? Then you're going to pull in the facts. You're going to go through the question, and you're going to write in the key facts that go to that issue, right? And then you're going to start doing the analysis with the buzzwords. So you're going to take the law, and you're going to take the facts, and you're going to put it all together, and you're going to start outlining it in a way that's just like a formula. And then you're going to start literally writing complete sentences that go in that format. There you go, right? You outlined it. That's going to take some time. You're not rushing into it. And you're basically going to start writing in and filling in the blanks, right? So there's your layout. If you do that format, your answer is going to be a lot clearer. Now, is it going to be difficult for you to write in that way? Probably a little bit, because you're forcing your brain, almost you're putting blinders on for all the other stuff. You're saying, I don't want to think about the other stuff. I'm just thinking about this stuff. And as Jennifer said, the more times you read this question, the more stuff is going to jump out at you. They write it in a way that's weird, that if you read it 3 times and you read it 3 more times, each time it's going to come across a little differently. And then you're going to say, okay, now keep in mind, what are they asking? So you're going to lay out the questions and the issues, and who are they asking you to argue for, right? Are they saying more for the plaintiff or the defendant? Because that's kind of what you're going towards. If they say neither and they're just say analyze, or they're saying plaintiff and defendant, okay, so you're going to take each side. Now, as Jennifer was pointing out too about conclusions, conclusions are important, but it should all lay out. The conclusion is probably the least important thing of your answer. The most important thing is how you got there, and are you clearly laying out how you got there? Is a grader going to see it and understand this is how we got from A, B, C, and eventually D? It should be clear. If it's not clear, then you should spend some time on analyzing about your layout, right? So now the other key important thing is we have a term, it's called cast of characters. So you want to lay out who are the people here, right? You got a plaintiff and the defendant. What are they trying to get, right? So you should spend 2 minutes, put plaintiff, put defendant, any other parties in there, and put a little bit, what are they trying to, what's their goal, right? What would you want them to do if you were them? Think through a little bit. It's so sometimes hard to put yourself in these fact patterns, to say, if it was me, what would I want? Because a lot of times that's really what the end result is, right? What makes sense. Now, sometimes you won't get all the facts that you want to get there, but again, you're struggling, and that's okay. You're struggling to use the facts they do give you to get to where you need to be, where they want you to be. And sometimes there's so many facts that are not what they want, and that's for a reason, right? They may be using those because they're counter arguments, or there are other things that they're trying to test you to say, are you're gonna go with all those facts? Are you gonna use some of those facts? Or are you going to ignore them? I don't think anything is in a fact pattern that should be ignored, but it's important to lay them out in the best way that makes sense. So it's important, if they're asking you to say analyze both plaintiff and defendant, you do that, and there should be enough facts to go both ways. Now, another thing I was noting here was on CivPro, because she had picked a CivPro question. CivPro, like some of the other topics, are not tested as often, and what we find is people struggle with stuff that's not tested as often. Why is that? Because you have less stuff to practice, right? We only use questions from past bar exams. So if we don't have that many in our database, it's because they haven't tested much, which means that if you're struggling, the other people are struggling too. So it's important to stay calm, because at the end of the day, if you throw everything up on your screen like a bunch of throw up, that's not going to look so well. Better to have a nice, clearly laid out argument that you're doing the best you can for what you know. Now, there's some interesting things that she also mentioned, such as what they're testing in CivPro. So on Erie Doctrine or other things like PJ and diversity, what we find is that, again, you're going to struggle on areas that are not tested as often. So do we get a lot of people that struggle with joinder and are freaking out? Of course. But how often is joinder tested, right? So know that they love PJ, they love diversity, they love some of these things. And the other things that they don't love as much, just know a little bit, right? Just know a little bit so you have a rule statement that you can throw out there. Now, moving forward, so the issue about the MSJs, what is the point of an MSJ, right? So if everything is decided before it gets through an MSJ, then you don't go to a trial, right? So there's no issue anymore. So if you're arguing for the plaintiff, you're trying to argue that there are issues, and that's why you want to go to a jury trial, right? That's why, or either through the judges being the jury. That's the point, right? If there are no issues anymore, then that's it. You stop right there, right? Now, sometimes if they give you what the court ended with, what they got, so they found with the defendant or the plaintiff. So you want to go in that direction if you can. But again, look at the facts. How many facts are they giving you? How many things are they telling you so you can put it in there? You want to read through the question. Now, another thing I noted too, as she was mentioning, was a motion to compel. So again, discovery. Discovery is a funny thing. If you're in the real law world and you worked as a paralegal or a law clerk, you probably write it like the back of your hand. Because why? Because most lawyers freaking hate discovery. It's the one thing they freaking can't stand. Every lawyer will give it to their paralegal, to their law clerk, and say, you do it. You do it, you do it, you. I can't stand them. They hate meeting confer letters. They hate motions to compel. And if I told you the stupid, annoying thing they do in LA right now, or for a long time, is like, even if you hated the other party's discovery responses and you want to do a motion to compel, guess what? You have to do an informal discovery conference in Los Angeles, and then you have to do it with the judge. And then if you get past that and you file your motion to compel, then you might get that point. But most of the time, the judge is encouraging you or with counsel to get it resolved, and that's that. So, but in going in towards the discovery, if there's something in there and you want to mention something, go ahead. It's okay. You can use some extra knowledge you might know from your experience or something that you read. That's okay. It's better to throw a statement that you know is right than to just say, I don't really know, I'm going to guess. Well, I'm not a big fan of guessing. I'd rather you stick with what you know, okay? Chances are, if you can think through a little bit, if you saw that someone is asking for something in discovery, and let's go into the next issue of anticipation of litigation. And it makes sense. Like, let's say, for example, as we have in another world I deal with, is if, let's say, you want to get something, and let's say it's a video surveillance or an accident report, and they made that way early, like before they even hired an attorney for it. Yeah, very likely that's going to be way early, and that should be discoverable, versus they made it later on and it should be more privileged. And even if it is privileged, guess what? Even again, is more knowledge you ever want to know. But like, you can actually get and try to argue that it's not actually privileged, and certain things still should be available through not privilege. So, anyways, moving forward. So basically, the fact is, on privilege or motion to compel, it's okay if you don't know a million things. Just use a very simple statement, and it's important when you're making your outline. It should be noted that on things that are not tested as often, just have a one sentence in your head. If it's discovery and it's like, okay, what's a request for production, and you don't really know what that means, just know, okay, so it's when they're trying to request documents, right, in discovery. In discovery, what is discovery? So discovery is where they're basically trying to gather information. The lawsuit is filed, they're trying to gather through special interrogatories or formal interrogatories or through request for a demand for production. And what's the motion to compel? So that's the whole thing, where like basically the other side doesn't tell you the answers that you want, and you want to force them to basically give you the answers. So you go through court intervention and you do the motion to compel and you ask for sanctions. In the real world, the judge rarely ever gives sanctions, and even if they do, it's minimal. But it's like, you just have to, because if you don't, then you might get sued by the client later on for malpractice. So it's a game. It sucks. But at the same time, you need to know certain things. And sometimes when you're on the plaintiff's side, you just don't know that stuff up front. And the only way you're going to know is through discovery. So it's important to know these things, and not like write a novel about, but know a sentence or two on these other issues. But again, most of the time, the things you're struggling with is because there's probably not much in there in the past bar exams. And the bar exams is the world. The bar exam questions are your world, not law school, okay? Law school is law school. It's more detailed. It's more analytical. It's very specific. You can write a page on Erie. Doesn't work like that in bar exam world. Bar exam world, it's crossover topics with, as she's mentioning, you might have some Civ Pro, and you might have a professional responsibility topic all mushed together, but it's your job to separate it out and keep it clean, right? Write it in a very simple way, like a math formula. Just keep it simple. Obviously, IRAC is the way to go. But again, if you're not sure how to outline, what to outline, the question is already giving you your IRAC. Like literally, the questions that they're giving you at the bottom, there's your issues, there's your I, right? Then there's your rule. Well, your rule will come about by what the issues are from the issue. So you're going to go, and your rule is you'll probably have a memorized statement, and that's where you can do it. Now, I'm a big fan of using the Barbary Convisor buzzwords. So if you can memorize just the buzzwords, just the basic ones for the main issues that are always tested, those are the words you're going to put in your outline before you start writing. And then when you start writing, you're going to elaborate, right? You're going to elaborate those buzzwords into complete sentences. Again, if you did proper preparation, like with a lot of our students that have written 15, 20 essays that are graded by actual good qualified people, then you're actually going to be, you're going to see a towards question, you're already knowing what the answers will look like. So you're just spitting it back out at them. Again, you're using past bar exam questions. Nothing in our database is anything other than from a past bar exam question. So our essays and our PTs, and before the bar exam converted to the PT in the early phase, we got permission from the National Bar Examiners, we grabbed PTs from there too. So only things that are the actual type. The only types are the 1.5 hour PT or the 1 hour essay, nothing else. Don't practice those old 3 hour PTs. I know that might be fun, but don't waste your time, right? Only do what they're testing right now. Now, one last thing before the time is up. The timer. Jennifer is dead on about timer. Timer is like gold, right? One of the things we still offer in our kits, we give a kit to everyone who signs up with us, is this clock. It's a little clock I got a long time ago. I had to live by it. It's just a clock, and it's giving you focus. So you're giving yourself a timer where you're saying, okay, so if it's an essay, I want to commit 10 minutes before I write anything. Now, it's going to be tough to do that. So you might, when I say write, back in the day it would be writing on a piece of paper. More modernly, it's typing on your screen. I would probably recommend, if you can hold off if you can hold off at least 5 minutes, don't type anything on your screen yet, okay? Struggle for that first few minutes. I know in the real world in the past, if you were typing next to somebody else, they'd be typing, but I'm sorry, my time's about up. I just want to say thank you very much for letting me speak. And if anyone has questions, check us out at barexamdoctor.com. Thank you.
All right.
Thank you very much, Todd. I'm putting your email address in the chat. Please, everyone, please, if you have questions for Todd, he has been doing this a lot longer than I have. Remember, I just passed the bar exam last May, and I started the Zoom meeting groups to help you, give you tips of what I remember that were helpful for me. And yes, and they do have tons of students that have passed. And I want to tell you that I found out tonight something that just blew me away. One of the people that took Bar Exam Doctor for the February test, she received an email today that one of her administrations was over 1390. So she is now eligible for the provisional license program. So she was ecstatic today, but she did use Todd for this last administration. And I saw some of the essays that she was typing besides the essay she was turning into the Bar Exam Doctor program. And she had brought her skill set for her essays up by really remembering to break it out and have that issue on top. Make sure that you have a rule statement. Make sure your analysis is answering all the elements of your rule statement and then concluding. And she did an excellent job on her performance test on the actual February 2021 bar exam. But she doesn't have to wait for her score. But, you know, if she did pass it, then she doesn't have to do the 300 hours under a supervised lawyer. So I really appreciate you all for coming tonight. I will send you a link to the YouTube replay of this. And thank you again, Todd, for coming. And I hope to see you all next week. Again, 6 o'clock, and we'll try to only make it 30 minutes and give you tips during the week. If you have any questions for me, please don't hesitate to send me. That's why I chose civil procedure tonight. That's why I emailed you the link to all of that information from another bar review program. So with that said, I hope you guys have a great night.